Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished their attention, for the court is now sitting. God save the United States and this honor.
Good morning, counsel. Mr. Anderson, you may proceed.
Good morning, Your Honor.
Morning.
May it please the court, my name is Carl Anderson. I represent the defendant appellant, Nexus et al. This case boils down to three primary points. First, the district court wrongly applied the black letter law in Illinois when it refused to consider the trade usage of the terms of the agreement. Second, the district court imposed its own standard instead of the bargain for standard of the parties in the agreement. It misapplied the holding of an out-of-circuit case and applied a reasonableness standard instead of the bargain for objective standard of exposure bargained for by the parties. And third, it justified these errors by imposing and misapplying the holding as it relates to the collateralization of immigration bonds. We believe
Mr. Anderson, as to your trade usage evidence, your expert only testified about the meaning of the term in the present contract. Was there any evidence presented as to the general usage in the industry besides that, just this contract?
Yes, Your Honor. There was also an expert provided by the plaintiffs in this case that generally spoke to the way in which the collateralization of bonds as it relates to the industry as well as this agreement.
What did he say? What did the plaintiff's expert say that would have helped you?
That it was actually that there was that the word exposure directly related to the anticipated and future losses of the word exposure, and that's where exposure is tied to, and there's evidence of that in the plaintiff's expert report.
Why did your conduct give rise to anticipated risk in this case?
Well, as it relates to immigration bonds, when there's a notice to appear, that creates the anticipated and risk of a future loss, and that triggers the exposure that we're directly speaking to here about the collateral security that is appropriate to request under the agreement. We believe that there's evidence in the record, and the case law presents that this is, in fact, is a case of first impression regarding the collateralization of immigration bonds. And we believe that the district court looked outside the four corners of the agreement and imposed its own collateral security amount regarding the reasonableness of the original demand. And that's not what the parties bargained for in the terms of the agreement. The terms of the agreement suggested that when a discharge of a bond is unobtainable, that the collateral security amount needs to be sufficient to cover all exposure under such bond or bonds. And we believe that
counsel, before it says exposure, it says acceptable to surety.
Yes.
That to me suggests the surety has some say-so over what's acceptable as exposure. You don't talk about that language. What does it mean?
Your Honor, yes, the clause, it looked in the totality. It is a back and forth. However, looking at the whole clause, it says when a bond participant or when a discharge is unobtainable, and that is the triggering mechanism. In fact, in many ways, the bond amount, the collateral security amount could go even lower than the penal sum, which is what we were discussing in our briefs. However, while it does need to be acceptable to the surety, it must be triggered upon the bond itself. And in the immigration context, we're only talking about the particular singular bond when that discharge is unobtainable. And therefore, it is not looked at in terms of the overall large pool of bonds. It's only that particular bond upon which security should be requested, because that is the particular exposure that the plaintiffs would be exposed to. And the Safeco case, I believe, is very determinative on this particular point. It says that there needs to be reasonably certain risk of future loss when the exposure is presented. And I believe that the record is clear that when the bond principle fails to appear, that is what's triggered, and that is what creates the exposure on the bond. And therefore, collateral tied to the particular notice to appear is appropriate.
But counsel, I mean, you could have. Go ahead, Judge Floyd.
How do you think the district court should have decided what was the appropriate amount of collateral?
I believe that the district court should have focused on the terms of the agreement rather than impose its own standard of reasonableness, directly tying the collateral security to the exposure under such bonds where there was a notice to appear. And these are sometimes moving targets in terms of at any given time, the bond participant can appear, can satisfy the conditions of that bond, and therefore the collateral security either would be held or returned, in this case, to the indemnitors.
Counsel, just to follow up a little bit, I mean, your argument about, penal sums and triggering events based on notice to appear, I mean, I understand that argument, and it would seem to me, that could be, you could draft an agreement that, has those sort of events and terminology in it, but you didn't, or you signed one that didn't. And I, so it seems to me we got to deal with the terms here. And I know your argument is under the trade usage, there's, that they mean the things you're talking about. But if we think the agreement is clear as it's written, is there any requirement to go outside the agreement to trade usage?
Your Honor, the black letter law of Illinois says that trade usage, explanation, and evidence can be considered by the district court, whether it's an ambiguous or unambiguous contract.
It can be, but if the district court doesn't, I mean, and I get the argument that maybe the district court should have addressed it, but if the district court thought the agreement was clear and did not need, outside evidence, even trade secret or trade usage evidence, I mean, wouldn't it be appropriate to apply the terms as drafted?
That's correct, Your Honor. However, the district court focused on the reasonableness of the request rather than triggering on the exposure under such bonds.
Sure. I think you have a point that, I mean, we can talk about it. I mean, I think the district court did, do that, and maybe that was improper, but nevertheless, I don't know that helps you, quite frankly, because I think if anything, the plain, or it seems to me that the plain language gives, a lot of deference to what the surety finds acceptable. And I'm not sure, I'm not sure adding reasonableness to it didn't help your client rather than hurt it.
Well, I think even if it's acceptable to the surety, but it has to be triggered and related to the unobtainable bonds themselves. It can't just be a sole discretionary amount. There's evidence in the record with comparison agreements that was a standard that they had negotiated in other contracts. However, in this contract, RLI specifically negotiated for the collateral security to be solely based on exposure, which means that the immigration bond process must be triggered by the bond participant's failure to appear. And therefore, we believe that the district court was looking outside the four corners and based its reasonableness determination of the collateral security amount on evidence and information that occurred subsequent to the original contract's formation. This was a form adhesion contract that RLI used. And therefore—
Adhesion, I mean, whoa. Y'all are two businesses. I mean, is your argument that you shouldn't be bound by the terms because if it's an adhesion contract?
No, simply, Your Honor, that this was a contract that they had used in many other cases. And we have shown that, and there's evidence in the record of those other agreements, but that both, and we're not saying that either party did not have a proper bargaining position.
Okay.
What we're arguing is that we both negotiated for this collateral security requirement to be hinged on and focused based solely on exposure of such bonds. And therefore, when the bond is and the discharge is unobtainable, the exposure and the reasonably certain risk of future loss on those particular bonds are what the collateral security required amount needs to be focused on. And while it needs to be acceptable to the surety, it can't go over and above the amount that is related to those unobtainable bonds, not the overall large pool. The immigration bonds themselves, and that's why we believe that Safeco and the district court are very informative, but they need to be looked at through the lens of the immigration bond context and framework. These are individual bonds, and the participants operate individually. They are not tied, they are not grouped together on, say, a project such as construction bonds, which is where Safeco is really very informative. And that is why we believe that this is a unique opportunity for the circuit to address the way in which collateralization under immigration bonds properly function, and where the bonds are triggered and focused very specifically to the particular bond that a claim has been made, which would be a DHS process when it issues its notice to appear.
What amount, if any, is due RLI?
Well, that is often a moving target, given that the notice to appear, several of them are, frankly, dozens, I believe currently are there. And the amounts vary. And there's a process by which the notice to appear, say, mature or ripen into, say, a notice of breach, and then we're into the indemnification. So it's oftentimes—
At the time you tried the case, what was the amount that was due to RLI, in your opinion? There's no moving target at that point in time.
Perhaps my opposing counsel can actually speak to the number, because I don't have it on the tip of my tongue. But there were, I believe, what triggered this were 3 particular bonds, if I'm not mistaken. And I believe the briefs do outline at the time the exact numbers that I don't have handy. So we believe it was to replace for the district court to replace its own judgment as to what was a reasonable amount, we believe that was acting outside the four corners of the contract and agreement itself, which was that the collateral needed to be based solely on the exposure of such bonds that were unobtainable and must be triggered, which is only triggered by the non-appearance of the bond principal.
Well, what about the fact that it was to cover also all liability that may come by reason of the bond itself? Then the language that it wouldn't have to be that event to be inclusive in all liability that may be there by reason of the bond, not by circumstances of the appearance, but by reason of the bond. How do you get around that language to somehow limit exposure to just those events?
Well, the Safeco case focuses on the reasonably certain risk of future loss. And the 3D clause looking at the 3D indemnity agreement clause focuses on the exposure of the unobtainable bonds. So I believe we're only focusing on the bonds where the discharge is unobtainable. So there's a notice of appearance, then the bond participant needs to either be located and appear and present themselves to the immigration administrative process. And when that does not, and that is what the collateral is hopefully ensuring, that if at the end, when there's a breach, that there's either exoneration or subjugation by the indemnitor here. And so the security really is only tied for that particular bond participant to that final event that DHS and the immigration process is directly in charge of. And actually, the appearance of the bond participant can satisfy the conditions of the bond.
All right. All right, counsel, thank you so much, Mr. Anderson.
Thank you, Your Honor.
Ms. Kat Santonis.
Thank you, Your Honor. May it please the court. Vivian Katzentonis on behalf of Apelli RLI Insurance Company. Nexus crystallized its opinions or its position here in its reply brief. And what it said is that there's only one issue before the court, which is the meaning of exposure. And what Nexus agrees, and what it agrees to say, is that exposure is unambiguous. They agree that it's unambiguous. They agree that the meaning is a reasonable expectation of loss, exactly what the district court held. And they also agree that extrinsic expert evidence is not necessary to interpret it. What they say is case law and logic dictate the same result. So there really is no dispute here. There is complete agreement as to what is the meaning of the word exposure. They even say that that's commonly understood in the trade usage as a reasonable expectation of loss. So again, there's no disagreement here with regard to what the meaning of exposure. But what they're saying instead is that in order to have exposure, there has to be this triggering event. And it's not only an exposure, they're saying in order to have a risk loss, there has to be some sort of triggering event, which is failure to appear. For that proposition, Next cites to no case law whatsoever and no evidence whatsoever. There's no language in the indemnity agreement at all to support this meaning. There's nothing in the indemnity agreement that somehow ties or limits RLI's collateral under 3D to some triggering event or to a claim or to a non-appearance.
Counsel.
Yes.
Counsel, could I ask a question before you go much further? The language that allows RLI as surety to request collateral, does begin, that sentence begins with, if such discharge is unattainable. What does that mean?
Well, Your Honor, the surety can request that it be discharged from its liability under the bond. And in fact, that situation happened here. And the discharge can be done in many ways. One way is that the Nexus could have posted and put in cash collateral for all the bonds. They could have just paid cash to discharge our liability. They could have done that with the Department of Homeland Security. They could have also obtained a replacement surety. If you look in the record, RLI contended that they were attempting to do that at many times, many junctures, to obtain our discharge under the bond. And so there's numerous ways in which you can obtain our discharge under the bond. They were unable to do so, and as a result, we were asking for collateral based on our exposure under those bonds. And a rich history to support our cost was to the bond. We had half years at the time of the hearing, at least, of a track record of what our risks had been and what our exposures had been on these bonds. And those are all the factors that the court considered in remedying, including the collateral amount. Again, with regard to
counsel, I don't know if the other judge, I'm having trouble hearing you, and it may just be the connection, but I don't know if you can move a little closer. I'm not an IT expert, but maybe that'll help. I'm sorry, I didn't mean to interrupt you, but I just want to make sure I can hear what you say.
Thank you, Your Honor. So Your Honors, what we have here is next completely agreeing to the definition. You don't even need to go to extrinsic evidence. We agree that the definition is the reasonable expectation of loss, and that's exactly what was applied here, consistent with case law in throughout the courts, throughout the district courts. We cited to numerous cases, at least a dozen, if not more, in our brief, which keenly construed and enforced similar provisions in surety indemnity agreements, require the deposit of collateral to cover the surety's uncertain risks and potential losses. Here, what we had was the district court followed expressly Illinois law and by the plain meaning of the indemnity agreement as written, finding it clear and unambiguous, as all the parties urged the court to do, and harmonizing all the provisions of the contract to render the meaning of exposure. In this regard, the court looked to what Nexus is really saying is a notice to appear is essentially the event when there's a non-appearance, as they're asserting. That is the breach. That is a claim made by the government. And so they're really saying what indemnity agreement says under 2A2, which is when there's a claim under the bond, then RLI is required to post funds to either pay that claim or that can be used as collateral. They're saying the exact same thing. Below, that's what they argue. They said 3D is limited to bonds that have been breached, which they said either a claim is asserted by the government or the bond principal fails to appear. In their appellant brief, they kind of take out the words "the claim" because they don't want to show the obvious contradiction. But that's what it is. When a bond principal doesn't appear, the government issues a notice to deliver, and that is a claim for our bond. That is conditions. Conditions of the bond are that the immigrant will appear, and that is a claim that's trying to limit RLI's collateral rights under 3D. And clearly, 3D is intended to prescribe much broader rights to collateral sufficient for all of our exposure. So,
Ma'am, what are or if there are any conditions preceded for you asking for the collateral?
well, Your Honor, there's no specific conditions precedent. The only condition in the bond is that we will request that they procure our discharge, and if it's unattainable, then they have to post the collateral. So, as the court is certainly well aware, any conditions precedent under Illinois law must be expressed unambiguously. So any arguments of any other conditions precedent run afoul of Illinois law and are contrary to the express terms of the indemnity agreement. Your Honor, our Nexus has provided no evidence whatsoever, nothing. And I know the court was asking about the expert report. It provided no evidence to support that somehow in the immigration context, which I would also note, they don't ever define trade. But, at one point they're talking about risk management trade. At another point, they're talking about immigration bonds. No trade identified. And they cite no evidence and no case law, as we stated, that talk about any sort of standard of a non-appearance. And
Counsel.
yes, Your Honor.
But may I get back to Judge Floyd's question a little bit? Are you saying basically it was the high breach rate that caused the triggering and request this collateral? Is that what drove it?
Your Honor, what drove the initial request for the discharge from the bonds or the collateral was a series of events, and there was a multitude of factors. There was the increase in the breach rate that the court is referencing. There was, at the same time, they had failed to post any collateral. At the same time, they were not paying breached bonds. We asked specifically for the payment of breached bonds, and the undisputed record is clear. They weren't paying them. Not only that, they gave representation regarding payment, saying that payments were made. In fact, they hadn't been made. They also advised us to raise the 2%. At that point in time, it was pretty at 50%.
Ms. Katsounis, I'm sorry, but you're breaking up very bad. Is there any way that you can scoot closer, or when you look down, it seems to break up the audio?
I apologize.
Thank you.
So continuing, Nexus had made representations. The breach rate was 2%. Nexus had made representations. The bonds run off within the vast majority of 6 months. But instead, we were having a breach rate that was climbing. At the end of December of 17, it was already at 27%, I believe. We were at, and the bonds outstanding were not being canceled within 6 months. And we were seeing long tail bonds that were lasting much longer. Nexus had stopped communicating with us. They were not giving us information on bond breaches. They were not attending meetings. So there was a host of undisputed facts that led to the initial request for discharge and for the collateral amount. And the district court found that all of RLI's requests were consistent with the indemnity agreement and well within its rights with regard to those requests, Your Honor.
Let me ask this question, and obviously you know well more about this than I do. You're counsel, you're the experts. But if I can make my question clear to you, there's a point, the beginning is the bond is issued, correct? There's someone who's before the immigration process, and they need to post a bond in order to be released pending whatever is pending before immigration, IJ, or the BIA, or whatever it might be, right? That's the issue. I call it the issuance, right?
Yes, Your Honor.
In terms of your clear understanding what exposure is, are you saying that exposure includes from the moment it's issued, or something has to happen after issuance? Because I want to make sure, are you saying that you're exposed once it's issued and that includes exposure, or there's something else after that, a subsequent act has to occur before it ripens into exposure? If you understand my question, I want you to answer that for me.
I do, Your Honor. Our exposure occurs at the time we issue the bonds. At that point, we are liable. We are legally liable to the government under these bonds. And, you know, exposure is the amount of liability or other risks to which a person is subject. And at that time, we are legally obligated and accountable to the U.S. government for those to satisfy the conditions under the bond. And that is our liability. The risk is the uncertainty, the chance of loss and the existence of that harm. And our exposure changes, obviously our risk of loss changes as we continue to go forward. And that's what the bond...
but here's the point though, risk doesn't have anything to do with exposure. Risk might obviously increase the likelihood you're gonna have to pay something, but if you Venn diagram it, exposure covers all of that. Because if it's a low risk you're exposed, that's just a matter of degree, but not definition. If you're saying that exposure includes issuance, that's the whole ball of wax.
Yeah, we agree, Your Honor, that our exposure is the whole ball of wax. The exposure, our exposure is the liability we're exposed to at the time that we issue those bonds. And, you know, the courts have interpreted in the indemnity agreements exposure to be the reasonably anticipated risk of loss. And so that is the definition that's been applied by the courts in interpreting the indemnity agreement. And that's what the indemnity agreement provides. There's many parts of the indemnity agreement that are to protect the surety from a risk of loss, because when surety issues a bond, it doesn't expect for any losses whatsoever. And so in that regard, the bond sets forth certain mechanisms, there's 4 of them, to ensure and protect that the surety never has a loss. And that's what the expectation is at the start of the issuance of the bonds, that it will be 0 loss. And so to protect that 0 loss, the surety has not only the right to indemnity, but they have the right to exoneration, which means that in this case, Nexus will stand in front of the surety every time and perform under the bond. And then the surety also is granted the right of books and records, and that is so that the surety can constantly evaluate its risk as the program continues. And even under paragraph 3C, which is the surety's right to the books and records, it's again, you have that right until you are discharged from all of your liability under the bond. It anticipates that you have this continuing right to review and analyze your risk. So you have those rights that then go to 3D, which is the right to ask matters, to cover your exposure.
No, I say it's like those mortgage contracts that say we can foreclose even if you've paid all of your mortgage payments if you do something in your dealings that we think that somehow changes the risk, I suppose.
That's right.
Ma'am, can you put your hands on section 3D of that agreement? Is it something readily available?
Yes, Your Honor.
All right. starting on the second line down, indemnitors will, upon request of the surety, procure the discharge of surety from any bond and all liability by reason thereof. Is there any limiting language that limits the collateral to breached bonds?
Yeah, not at all, Your Honor. And that's exactly what the district court found. And that is consistent with even the case law in numerous districts that have held the same, including the Safeco case that the court followed as affirmed by the Second Circuit.
So, counsel, Judge Floyd, are you finished? I'm sorry.
Yes.
Okay. Counsel, I understand that part of your argument. Do you believe it was appropriate for the district court to include a reasonableness standard in evaluating exposure? Because it didn't sound like that was your argument before the district court. It sounded like before the district court you said, much like you, I think, are saying today, that this contract gives you the right to demand collateral, for the whole ball of wax, so to speak, as Judge Gregory said. And, of course, you didn't seek that collateral for that amount. But my question is, do you agree that the district court was correct in using the term reasonableness to define exposure and taking evidence on that?
Yes, Your Honor. I think, certainly we believe that the $10 million we asked for was reasonable, the circumstances. But in this situation, Your Honor, the district court is granted broad discretionary authority to grant specific performance. And it's within the court's realm. In fact, when the court is enacting its broad discretionary authority, it's confined to and must use reasonable standards. Otherwise, it'd be an abuse of discretion. And so,
why would it? I mean, I know there's an inherent obligation of good faith and fair dealing, but if the agreement says it's whatever collateral is acceptable to you based on the risk, isn't inserting an objective reasonable standard inconsistent with that?
Your Honor, I believe that the court, again, it's a specific performance remedy. And so the court was permitted. We believe that our request was consistent and with what was acceptable to us and what was reasonable. And I think that the court, by interjecting reasonableness, was interjecting his discretionary authority under specific performance.
Okay.
Thank you. Thank you, counsel. Mr. Anderson, you have some time reserved.
Thank you, Your Honor. I believe, Judge Floyd, you raised a very interesting question as to really what is the limiting factor. And I believe that paragraph 3D of the agreement has that limiting factor language in it.
Where is that language? Where is that language? What does it say?
It says that if the discharge is unobtainable, indemnitors will, at the request of the surety, either deposit collateral with the surety, acceptable to the surety, sufficient to cover exposure under such bonds, or make provisions available. I believe we're talking about where the discharge is unobtainable. So there's a period of time when DHS has issued a notice of appearance, and the ultimate discharge of this particular bond and the participant subjecting themselves to appear at the DHS hearing, that is at issue. And I believe if the district court had properly addressed what this exposure was and what the process was in terms of the immigration bond framework, we wouldn't be having this discussion. Instead, it replaced its own judgment as to what was a reasonable determination rather than the objective language contained in this particular clause of paragraph 3D.
But didn't RLI ask to discharge all bonds?
And Your Honor, at the very beginning, there was no, that wasn't going to be possible by Nexus, given that really the way in which the bonds and the process works is there's no money that changes hands other than the premiums paid by Nexus to RLI when the bond is actually created. The obligation is created. The satisfaction occurs either upon the appearance of the bond participant or later when Nexus, as the indemnitor, steps in the breach and pays the subjugation or exoneration of that particular bond. And really only excuse me.
I was going to say, I don't think you answered Judge Floyd's question. Maybe the question was, didn't RLI request all bond?
They did. And in light of the fact that Nexus could not produce or discharge all the bonds, they had their demand of the $10 million collateral security payment, which we believe was not a good faith effort to discharge all the bonds, given the circumstances.
I guess it goes back to Judge Qualibam's query to you. It's your contract. It is clearly, it's favorable to RLI when it comes to making them comfortable to make sure they stay ahead of the curve. And as counsel said, that we have no exposure, have to pay. We stay ahead of it. It's written that way. It was never really intended that they would have to pay anything. And therefore, we want to make sure we're comfortable. We have a margin ahead of ourselves, not behind. I mean, that's the contract. And you're not saying it's a contract adhesion. You seem to be arm's length bargain to corporations. But because you start off answering Judge Floyd's question, like, well, that's not possible. We don't have any money. The only money exchanged. Is that the way we interpret the contract? But how deep your coffers are to satisfy the terms of the contract?
Well, Your Honor, we're not saying that we didn't have it. In fact, no bond, RLI has been compensated for any of the breached bonds to date. They have not had to pay any amount of money on those particular bonds. And in fact, they have received the premiums throughout this. Now, there has been discussion and there's evidence in the record that it took some time, but to date, RLI has been compensated and Nexus has been making those payments.
Including interest, all interest?
I would have to verify whether the interest has been made, but.
Well, okay. Well, you can't represent that all money's there.
No, other than what was in our briefs, Your Honor.
Okay.
I see my time is up.
Yes. Any further questions of the court? All right.
No,
Mr. Anderson, you're on your rebuttal, so I'll give you a minute to close your thoughts in fairness to you.
My original thought was back to Judge Floyd's question, and I would just state that the nature of the collateral provided is not always if the district court had focused entirely on the exposure and we had actually examined what the exposure was under the particular bonds, we would be in a much different situation. And instead of focusing on exposure, the district court replaced that bargain for term in the agreement with its standard, with its reasonableness determination.
All right. Thank you so much, Mr. Anderson and Ms. Katz-Antonis. Thank you so much for your arguments.
Thank you.
We would love to come down and shake your hands as we do in the Fourth Circuit, but we can't do that. But no, nonetheless, we very much appreciate your being here and wish you well and stay safe. Thank you, counsel.
Same to you. Next time, Your Honor. Thank you.
Thank you.
Thank you. We proceed to our next case.
Good morning, Your Honor.
Good morning, Mr. Tobin. You may proceed.
Thank you very much. Good morning. May it please the court. I'm Daniel Tobin. I'm here for defendant appellant PNC Bank NA. PNC believes that the Fourth Circuit should find in its favor on either of two independently sufficient grounds. One, that by application of common law contract principles, Mr. Lyons became bound by the arbitration agreement that's at issue as of its effective date on February 1st of 2013. And then second, because the language of the relevant amendments to the Truth in Lending Act and Dodd-Frank do not reach this particular agreement. So I'd like to start with the contract issue, if I may. And the court's, of course, aware that there's a factual sequence that's important here. There's a residential mortgage credit transaction that took place in 2005 when Mr. Lyons obtained a home equity line of credit. Mr. Lyons elected to enter into a different kind of relationship with PNC 5 years later when he
Counsel, if I could interrupt you, and yeah, both parties have briefed this very well and helped me at least get here. So I'm going to kind of go straight to one of the statutory issues. Do you is the way you believe, the way your client believes the arbitration provision should work, would it bar Mr. Lyons from bringing an action in an appropriate district court in the United States?
Well, no, Mr. Lyons did in fact bring an action in a district court of the United States, so he was entitled to do that.
But isn't the way you seek to use the arbitration provision to prevent that action from proceeding in district court?
Well, right, and the reason that PNC takes that position is because this arbitration agreement is not covered by the provision of 1639C that you're referring to. And,
well, I know that, but and I understand that argument, but under the text of that provision, it says that no other agreement relating to, and we could debate relating to, and that I suppose is your argument, but the effect of what you're trying to do with the arbitration provision would in fact bar Lyons from bringing the action in a district court of the United States, correct?
Well, there's no question, Your Honor, that the Dodd-Frank amendments to TILA, where applicable, require that consumers be permitted to bring actions in federal court and that they not be subjected to arbitration. So that's
as to Mr. Tobin, as a follow-up on Judge Quattlebaum's question, the arbitration provision became effective on February 2013, but is it not true that it didn't become binding until the opt-out period expired, which would be June 11, 2013, 10 days after Dodd-Frank's was enacted?
That is not correct, Your Honor. And the reason that's not correct is because, as the court has consistently applied, the purpose of construing a contract is to effectuate the intentions of the parties. And the first task for the court is to review the language that the parties used, and if unambiguous, to apply it. And here we've got language that says, this arbitration will apply to you and us as of the date your account was opened, or if you were an existing customer, as of the date of this agreement, which is February 1st of 2013. The cases that were cited by Mr. Lyons in his briefs addressed a different set of facts, one that is decided by the same principle, but those facts are as follows. And I'm thinking of the Gupta case, but the other cases that they cited had the same facts. And that is this. Employer sends to employee an amendment to a contract that says, as of 30 days from now, we're going to arbitrate any disputes. And you have until then to opt out. So that contract says, we're specifying an effective date, it's later, and you can opt out until then. So the court didn't have any problem concluding, okay, the effective date is as written, October 2nd, And because there is no opt-out, it applies. Here, same principles, have to apply, read the contract as written. And as written, it says the effective date for existing customers, which Mr. Lyons undisputably was, is February 1st of 2013. So
the opt-out period doesn't count.
It
Doesn't
doesn't.
mean anything.
And the reason for, I'm sorry,
I'm going to say it doesn't mean anything in your view.
No, I disagree. Contracts very frequently contain termination provisions. They very frequently contain opt-out provisions. If we enter into a contract that calls for either party to terminate after a period of time or upon an event, that can happen and the contract can terminate. But that doesn't mean the contract isn't enforced during all those months. And that's precisely the facts that we're dealing with here.
Counsel, just I got two questions for you related, I guess, really to the 2010 account, where it seems like that effective date is potentially a bigger deal, assuming we have jurisdiction over that issue. But I don't think either side argued this or addressed it, or if I did, I'm sorry. But 14C3 says that a provision of the Dodd-Frank for which regulations have not been issued 18 months after the designated date take effect on that date 18 months later. And that date, 18 months, I think, is January 21st, 2013. And so why... I don't think by that time regulations had been taken effect or had been finalized. So why aren't we looking at that date, January 21st, 13, as the operable date rather than the date of the subsequent regulations? It seemed like the 18 months expired, the regulations weren't final, so by statute we should be talking about that date rather than the date of the regulations.
Your Honor, the Bureau, as I understand it, addressed this explicitly by issuing guidance first to indicate that it would issue a final rule that would set the date. It accepted notice and comment, received a lot of comments, and then issued its final rule that set the date at June 1st of 2013. So you think the Bureau's actions, essentially, said, even though we haven't done the regulations yet, it seems like that would undo the language of the statute to me. But I'm not. I'll ask them that maybe. Well, Congress assigned to the CFPB the duty to set an effective date. And I think that was an important consideration on Congress's part. It wanted the agency that was going to have responsibility for enforcing this statute to determine when, and I think that's an important point on the retroactivity issue. Congress clearly did not want this statute to operate retroactively because it wanted, in fact, it didn't even want it to operate prospectively until the Bureau had an opportunity to enact the regulations. So I think that the Bureau did act reasonably in taking its time. It was a very complicated process, and taking in all that information. And I think that given the fact that Congress did intend for the Bureau to have this power, that the court should defer to the Bureau's actions in setting the date.
And I don't want to beat this to death because maybe I'm the only one focused on it, but I understand that, but it also had the provision I said that if they didn't do it within a certain date, those provisions take effect at a certain time. It seemed like, you're right, they gave the Bureau the opportunity to set dates, but they kind of had a hammer, if you will, that you got to do it by a certain deadline or or the date we set is going to apply. Am I wrong there? I mean, I may be missing the boat.
Well, the only thing I would say on that, Your Honor, is that, and this is something that this court recognized in the Santoro case, which is a very interesting analogous case involving an anti-arbitration provision within Dodd-Frank, that it's the job of the court to not always simply apply a literal meaning to a statute, but to take into account the context in which that's been enacted. And here the context clearly is that we're dealing with a very complicated regime, a lot of new requirements being imposed by Congress, and the Bureau being assigned the responsibility to determine when that's going to be effective. And I think that given that context and given all the history that took place during the regulatory process, that yes, the court should treat the effective date that the Bureau assigned, because Congress gave it that power, as the date that's controlling here.
Mr.
And
Tobin,
I think that, I'm sorry.
We'll finish up with Judge Qualabong. If you had something that you mentioned Santora, of course, that was a whistleblowing case, but
Well, actually, I think it was not a whistleblower case.
not whistleblowing.
Which was exactly why the court found that the Dodd-Frank provisions would not apply, even though, I mean, the language that was that Mr. Santoro was using from Dodd-Frank was very literal and very clear that that an employment agreement that doesn't contain this carve-out is not enforceable. That's what the statute said. And this court looked at that and said, well, but what we're regulating here, what Congress was attempting to regulate here, was whistleblower claims. This is not a whistleblower claim, so we're not going to apply it literally. And I would think that addresses Judge Quattlebaum's concern.
Mr. Tobin, let me go back to, you're saying on terms of the arbitration clause, the
Yes,
way
sir.
you read it, you're saying that if you're an existing customer, you get no opt-out.
No, he could have opted out. He could have opted out.
And how long did he have to opt out?
Well, he had multiple opportunities to opt out.
Now, how long? How long would it extend to him?
The date that Judge Floyd gave initially was correct. He was given until June 11th. But the contract says that the effective date is February 1st, and that means that between February 1st and June 11th, the contract was in effect. And because Mr. Lyons never opted out, it remained in effect thereafter.
No,
So
but what happened in between was Dodd-Frank, didn't it? Before his time expired for opting out, the law changed.
Yes, sir, but the effective date had already begun running because he's an existing
But no,
customer.
it says the effective date will be the date of your agreement if you're an existing, unless you opt out by providing proper notice as set forth here. So unless means you're changing the effective date. It would have to mean that.
Your Honor, I disagree.
Well, that's what it says. That's what it says.
But that language simply gives to Mr. Lyons the power to terminate the contract, to opt out of it. It doesn't change the effective date.
No, it doesn't. It says if you're an existing customer, the date of, it says the effect of this arbitration provision will be as of the date of this agreement. Okay, that's given the effective date, unless you opt out. So it wouldn't be effective until his time for opting out expires, would it?
I don't think so, Your Honor. First of all, obviously, he did not opt out.
I
But
know
even
that.
if he did opt out, it would have been in effect until he did opt out because of the plain language of the agreement. So it isn't an offer and acceptance situation. He's an existing customer. They have an account agreement. It's in effect. And it's been amended by PNC in accordance with its rights under the agreement. And the opt-out is simply a termination clause that can come into effect later, but didn't. Doesn't change the effective date.
All right. I understand.
I see that my time is up for my first.
All right. Thank you, Mr. Tobin. Ms. Noble?
It please the court. PNC is trying to evade Dodd-Frank's restrictions on arbitration in the home lending context in two ways. First, PNC claims that Dodd-Frank's ban doesn't apply at all because the arbitration clause is in a separate deposit account agreement. But that doesn't matter because Dodd-Frank expressly states that a provision in agreement that relates to the home loan is covered by its restrictions. And then second, PNC tries to sidestep Dodd-Frank by arguing that the parties agreed to arbitrate in 2013. But the 2013 arbitration agreement was actually formed 10 days after Dodd-Frank went into effect and has been superseded by many other post-Dodd-Frank agreements.
Counsel, I want to give you plenty of time to talk about the merits, and I appreciate those. But with respect to the district court's order compelling arbitration related to the 2010 account, how do we have jurisdiction over that based on Section 16B of the Federal Arbitration Act?
Your Honor, this court has pendant appellate jurisdiction because the district. Go ahead. Because the district court's partial grant of the motion to compel is inextricably intertwined with the court's partial denial of the motion to compel. It's based on the same subject matter, same legal questions, and specifically, PNC's argument on appeal is that the 2013 arbitration agreement requires Mr. Lyons to arbitrate all of the TILA claims. Mr. Lyons' response is...
Go ahead, finish. I'm sorry.
Mr. Lyons' response is that the 2013 arbitration agreement is entirely unenforceable. So there's no way for this court to decide the appeal without also deciding that cross-appeal issue. I think Your Honor's concerned particularly about Section 16B, which says orders compelling arbitration are not appealable. But
right, I've looked through the pendant jurisdiction cases, I certainly may have missed this, but I'm familiar with that. But I'm not familiar with one where we have an express specific bar to jurisdiction like this. I mean, normally you have an order, and then you have that is appealable, and you have one that may not be. It may be interlocutory or something like that. But and you have a general statute saying those orders aren't appealable. But here 16B is specific and express, and I realize they're very connected. It's the same people, and it would make matters complicated. But I can't see why not appealing the order on the 2010 account prevents us in any way from effectively addressing the 2014 account. I mean, again, it's a mess. I can see the complications that might ensue, but I'm not sure that those overcome an express jurisdictional thing like this.
Your Honor, there are cases that have done that. The Second Circuit, Ninth Circuit, and DC Circuit, as well as the Eighth Circuit in dicta suggested they would, have all held that Section 16B does not restrict pendant appellate jurisdiction. And those decisions and those cases are all cited within the jurisdiction section of PNC's reply brief. And importantly, those cases make sense because Supreme Court has repeatedly said that Congress legislates against the backdrop of common law principles. And pendant appellate jurisdiction is all about when the court can assert jurisdiction over non-appealable issues, over issues that normally it can't assert jurisdiction over. And so because there's no express prohibition, there's nothing in the statute that suggests Congress is trying to override that common law principle of pendant appellate jurisdiction. All of those circuits have held that 16B does not prohibit or restrict pendant appellate jurisdiction with respect to motions to compel arbitration.
Ms. Noble, let me ask you, given that the initial account agreement included the right to amend, why would the subsequent agreements be considered new contracts?
Your Honor, that's just a matter of Maryland law. Maryland law has repeatedly held that anytime you modify a contract, even if you're pursuant to a notice procedure, that is a formation of a new contract. It's a new meeting of the minds. You can see all of the citations to Maryland law on page 7 of the reply brief. And that means that every modified version of the account agreement, including the 2015 agreement, which actually modified the arbitration clause in particular, are new versions that apply. And because they're new post-Dodd-Frank versions, under Maryland law, when a contract is formed, existing law at the time becomes incorporated into that contract.
Well, does Maryland distinguish between amendments and novations?
Your Honor, I think actually not. Repeatedly, they have used the word novation, like in the Berman case, coinciding with the term revision of an agreement. Regardless, I think this would also meet the standards of a novation. But But either way, it's a modification of a contract is the language used in Maryland Court of Appeals decisions, and a modification results in the creation of a new contract. In fact, in John Deere, the Maryland Court of Appeals actually held that when you have an open-ended contract that can be renewed, so a party has a choice like every 120 days to renew it, it's actually a series of 120-day contracts. And that whenever it's renewed, whatever law then exists at that time becomes incorporated into the contract. And that's exactly what the Maryland Court of Appeals held in John Deere. And so for that reason, this court doesn't even need to get into the weeds of the 2013 arbitration agreement's formation date, because it was clearly superseded by lots of subsequent contracts that are subject to Dodd-Frank. If this court did get into the weeds, though, it is very clear that the 2013 arbitration agreement was formed on June 11th, 2013, 10 days after Dodd-Frank went into effect. The June 11th is the opt-out deadline. PNC continues to quote the language from the arbitration agreement, but then leaves out the clause starting with unless. It says it'll apply starting on February 1st, 2013, unless Mr. Lyons opts out. PNC is conflating the time frame that's covered by the arbitration clause once an agreement is formed with the date of actual formation. Under Maryland law, there is no contract if there is no binding obligation. And if a dispute had arisen in April 2013, Mr. Lyons would not have been obligated to had any binding obligation to arbitrate that because his deadline to opt out still hadn't passed. Maryland Court of Appeals and many circuit decisions have recognized that when that opt-out deadline passes, that's when the agreement becomes binding, and that's when the agreement is formed. Another way to think about it is just like there's an offer on the table, and it's not accepted until Mr. Lyons fails to opt out by the necessary time period.
But counsel, you could do that, right? I mean, you could say we don't have a binding agreement until June 11, but the agreement I make on June 11 is that the effective date will precede when I said, and isn't that pretty much what PNC is saying?
Your Honor, you're absolutely right that you can contract to commit yourself to arbitrate disputes that arose in the past. The problem is what matters here is the date of formation because Dodd-Frank went into effect before that time. And under Maryland law, when a contract is formed, the existing law at the time under John Deere is incorporated into that contract, almost as if it was expressly included. So that means that, yeah.
I understand. Thank you. Could you address the question I raised about why, I appreciate this is a complicated statutory regime, but why are we even talking about these June dates based on 14C, I can't read, C3, which says if you don't have it in effect within 18 months, the statute goes into effect on that date?
Your Honor, I actually believe that this is discussed on page 9 of our opening brief, and that the CFPB issued the final rule the day before, on January 20th, 2013. It's confusing based on the date on the document, but they explained that it was released on the day before that date came through. Okay,
so it was released within the 18 months. I appreciate that clarification. Thank you.
Moving to the other question regarding the scope of Dodd-Frank, PNC tries to avoid Dodd-Frank's restrictions on arbitration altogether by pointing to an arbitration clause in a separate deposit account agreement. The easiest way to affirm the district court here is on section 1639C E3, because that E3 provision expressly prohibits any provision in an agreement relating to a home loan from being applied or interpreted so as to bar a consumer from bringing a federal claim in court. And here, the deposit account agreement clearly relates to Mr. Lyons' home loan because according to PNC, that account agreement provides a means by which the bank can collect payments on the home loan. PNC argues that the two are unrelated, but the basis of PNC's motion to compel was that Mr. Lyons' TILA claim, which is alleging unlawful collection on a home loan, arises out of or relates to the deposit account agreement. That's on JA 101. So PNC cannot claim that the account agreement and the home loan are related for the purposes of compelling arbitration, but then say they're not related in order to dodge a statutory restriction on arbitration. In addition, the characterization that PNC makes that this is just about a waiver of statutory actions and not about arbitration is an interpretation of E3 that no court has accepted. It also isn't consistent with the text or structure of the statute. E3 appears under a subsection heading entitled arbitration. PNC relies on cases that talk about when a statute authorizes a plaintiff to bring a cause of action in court and says that doesn't preclude arbitration. But here, the language is very different. It's an express prohibition of waiving the right to bring your claim in court. Indeed, it almost directly matches the language the Supreme Court used in Glimmer when describing how Congress could go about and overriding the FAA and limiting mandatory arbitration in certain contexts. E3 is therefore the easiest way for this court to affirm the district court below, though we also think the court could affirm under E1, which says home loans cannot include mandatory arbitration agreements. And here, the account agreement purports to actually amend key terms of the home loan, like the collateral and the means of collection on that home loan. It would be a massive loophole in the statute if they could simply stick terms in separate documents to get around restrictions in TILA. I think, finally, we believe there's no reason to consider the retroactivity of Dodd-Frank, given that the 2013 agreement post-dates Dodd-Frank and has been repeatedly superseded by post-Dodd-Frank account agreements. Nonetheless, in our briefing, we outlined several reasons why, even if there was a valid pre-Dodd-Frank arbitration agreement, applying Dodd-Frank's arbitration restrictions here would not be impermissibly retroactive. If the court has any questions on those arguments, I'm happy to answer them, but otherwise we'll rest on our briefs there, and I'll reserve the remaining time for rebuttal.
Thank you so much, Ms. Noble. Mr. Friedel?
Good morning, Your Honor. Kevin Friedel for the Consumer Financial Protection Bureau. And I want to start by addressing Judge Quattlebaum's astute point about the timing issue here, the dates here, because I think it's not entirely clear unless the court also keeps in mind another rule not cited in the parties' briefs. But so the Bureau issued a procedural rule in 2012. This can be found in the Federal Register at 77, the Federal Register 76-353. And what that procedural rule said is, for purposes of the statutory deadline here and similar deadlines for rulemaking elsewhere in Dodd-Frank, what was meant by issuance is when the Bureau published a rule on our website, not the date that it is then later appears in the Federal Register. So this rule implementing the arbitration restriction was issued January 20th, 2013, so within that 18-month deadline. And that's why I think it's appropriate to look at the June 1st effective date that the Bureau set in that rule. I want to take a step back just to be as helpful as I can, try to clarify the issues that the Bureau is addressing here as amicus curiae. So our position can be summarized briefly. First, we think the arbitration restriction applies here because the arbitration clause that the bank seeks to invoke was contained in a contract that relates to the plaintiff's home loan under 1639C or EC3. I'll just call that paragraph 3 going forward if I could. Second, we think that the plaintiff can rely on that arbitration restriction at least as to the 2014 account, because all of the potentially relevant events there took place after the statute took effect. And then finally, we haven't taken a view on the same sort of timing issue with respect to the 2010 account. Resolution of that issue in this case turns on a number of very fact-specific issues, including the parties' specific arguments about waiver and estoppel based on what happened in the district court, the appellate jurisdiction questions that Judge Quattlebaum has raised. And so we haven't weighed in there. What I would say, though, is when the bank claims in its reply brief that the Bureau agrees with them on any issue that it hasn't specifically addressed. That's incorrect. Court shouldn't credit that. Yes, Judge Paul. Yes.
Does the Bureau have a position on the retroactive application of the provision that you do have a position on C3? Do you have a does the Bureau have a position about whether that operates retroactively?
We haven't. No, we haven't taken a view on sort of how the court should analyze this timing question there, because we think those questions are only relevant to the 2010 account. For the 2014 account, if the court were to look, yes, Your Honor.
Yeah, and I'm just trying to make sure my question's clear. I'm not asking whether you have you've made it clear you don't have a position on this particular situation. My question is a little more basic. Does the Bureau have a position about whether C3 operates retroactively? Let's say it was just, there's no question about the arbitration agreement. It was well in before the Dodd-Frank deadline, valid existing contract that preceded anything to do with the Dodd-Frank. Dodd-Frank comes into existence. Say your interpretation is right. Does it operate on previous agreements?
We haven't offered a view on that in any other forum as well. So I could just point to what we have in the rulemaking notice. But there's not some other rule that would speak to that. So turning to this issue that really was the focus of our brief, we do think that the deposit account agreement plainly did relate to plaintiff's home loan. It purported to give the bank a means of collecting payment on that home loan, which the bank then exercised. So any sort of uncertainty as to whether that account agreement related to the home loan was definitively resolved by the bank's own actions. And Mr. Tobin pointed to this court's previous decision in Santoro. We just don't think that that's relevant here, because what the plaintiff is trying to pursue is a claim that is very much about his home loan. So there's no need for the court to interpret this provision to sweep in other claims that might have no connection to a home loan. And I see that my time has expired. I'm happy to answer any other questions the court might have.
All right. Thank you, Mr. Freedom. Mr. Tobin, you have time reserved.
Thanks very much, Your Honor. Well, a number of points to make, and I guess first I'd like to thank my co-counsel for being better prepared on Judge Quattlebaum's question than I was. I appreciate that information, and I apologize, Judge Quattlebaum, for not having that information.
No issues.
Thank you, sir. I would like to address this contract formation question, which I think is very interesting, and there is Maryland law that's very germane to this point. There were two cases that were decided, Cheek and then Holoman, that addressed whether an after-the-fact arbitration agreement is enforceable. And the first of those, Cheek, as I recall, found that if the party that is in PNC's position and is now requiring arbitration of disputes retains the power to terminate it at any time, then that's an illusory promise and we don't have a contract and it's not enforceable. Then in Holoman, the subsequent case, the court said, but if the promises are mutual, if both parties are bound to the arbitration agreement, there is consideration and we have a binding agreement. That's precisely the case here, because effective February 1st of 2013, there is a binding mutual obligation on the part of PNC and Mr. Lyons to arbitrate any disputes that occur thereafter. And PNC is bound by that, which means that Mr. Lyons was entitled to enforce it and demand arbitration for any dispute that arose during that time. So the contract formed effective February 1st of 2013. It could have been terminated thereafter, but the binding contract was formed by that mutual exchange of consideration. February 1st of 2013 should be the
Mr. Tobin, assume you're right there. How does that help you with respect to the 2014 account? Well,
the 2014 account, I'm helped by that because Mr. Lyons became a deposit account customer of PNC in 2010. He was an existing customer in 2013. He became bound to the arbitration agreement in 2013 on February 1st. And because he remained an existing customer thereafter, he's bound for purposes of the 2014 agreement as well. I respectfully disagree with Ms. Noble's characterization of Maryland law. What this account agreement allows PNC to do is to amend its agreement. And amend means amend. It doesn't mean replace. It means correct. It means improve upon.
But again, if you're right there, counsel, I mean, if you're right there, there are two accounts, which to me complicates this a little bit. Admittedly, there's one set of terms that apply to the accounts, but I don't see, I mean, even if you are right under contract law that it's an amendment and not a novation or modification, and even if you're right about its effective date, going back to the contract date, I just don't, if you open up a new account, it seems to me hard to argue when you open up that account that applies to an agreement, and Dodd-Frank unquestionably is in place by then, by the 2014 account. I don't understand how contract law helps you with a whole new account.
Well, Your Honor, because there's a single contractual relationship between depositor and bank that started in 2010. And Mr. Lyons, as part of that two-party agreement, said that as of February 1st of 2013, as an existing customer, I'm bound to the arbitration clause. And there are other references, we include them in our brief, to the definition of accounts. So this applies to, this account agreement will govern your relationship with the bank. This covers account or accounts. So it covers everything, and as an existing customer, he remains bound. I mean, if that's what I have for that, Your Honor. I hope it's satisfactory, but I do want to address.
No, thank you. Appreciate it.
Sure.
It's satisfactory, but it certainly undermines the purpose of Frank Dodd as a statute passed by Congress to protect consumers.
Well, Your Honor, I'd very much like to address that. We're talking about Section 1639C of Dodd-Frank, and that section has extensive new requirements in the area of residential mortgage loan origination. For example, there's limitations on banks have to make sure that borrowers can repay. You're entitled to a presumption if you make sure it's a qualified mortgage loan. Prepayment penalties are limited. Credit insurance is limited. There's negative amortization is prescribed. This is a section that addresses residential mortgage loan origination. PNC has a different kind of relationship with its customers, and that is as a bank to its depositors. I mean, as a lender to its borrowers, such as Mr. Lyons is the debtor, and PNC is the creditor. The shoe's on the other foot when you're talking about a deposit account. PNC is the party that owes the money to Mr. Lyons. So it's an altogether different relationship. Congress regulates both of these areas. I mean, there's a Truth in Lending Act that gets a lot of attention, but there's also a Truth in Savings Act, 12 U.S.C. 4301. So what did Congress intend to regulate when it enacted this statute? It intended to regulate residential mortgage loan origination. PNC was not on notice that its use of its account agreement to offset payments that were due to it were suddenly proscribed by this provision that actually isn't even in the anti-arbitration clause, which is sub 1, but it's rather in sub 3. We think, Your Honor, that this is, as the court noted in the Santoro opinion, an elephant hiding in a mouse hole. I mean, if Congress had intended to reach this agreement, it would have said so much more explicitly. Instead, yes, sir.
So, counsel, I mean, people. It's the trouble with what Congress intended, because everyone can have their views on that, and I at least respect your opinion, but it seems I don't understand how that if we go to the text of C3, it doesn't specifically address what you're attempting to do with the arbitration agreement. Yeah, I get the contract retroactivity arguments. I mean, those are something, but in terms of just how the text operates, unless relating to has, I mean, maybe that's the hook, but, we got the Supreme Court and this court has pretty broad language about relating to. And so, it's hard for me to know whether I can truly determine what Congress intended and go on that. But what I can go on is what they enacted. And what they enacted seems like it applies to your use of the arbitration agreement.
Your Honor, I respectfully disagree. Congress is clearly trying to regulate mortgage loan origination. When the CFPB explained its guidance on this, it said, you have to understand, these regulations apply to contracts for a residential mortgage credit transaction. The account agreement that PNC entered into with its depositors is not a contract for a residential mortgage credit transaction, nor is it related to it.
That's one. Yeah. That's one. What you were just talking about is subsection 1, correct? 4?
No, I'm referring to subsection 3, though, the section that contains the related to language.
Okay. I thought you were using the word 4, and I thought that was in subsection 1.
I'm sorry, Your Honor. I'm not referring to the regulation that the Bureau enacted in order to enforce the statute. So there was a question, okay, so how far do we go? How far afield of the mortgage note is this supposed to go? And the Bureau said, you need to understand, sometimes at a loan closing, lots of documents get executed. So you can't just, a creditor can't just stick an arbitration requirement in an ancillary agreement at a residential mortgage credit transaction. This is not 5 years later any part of residential mortgage credit transaction. And for that reason, it's not part of what's being addressed by the statute or by the regs. My time is long up, Your Honor. I'll be glad to answer any other questions.
All right. Thank you, Mr. Tobin.
Thank you.
Ms. Noble, you have some time reserved.
Thank you. If I could first start on the question of when the 2013 arbitration agreement was formed. PNC argues that there was mutually binding obligation to arbitrate starting on February 2013. But if you look at JA 147 in the district court briefing below, PNC stated just the opposite. They stated that there is no binding obligation to arbitrate until the opt-out deadline passed on June 11th. In addition, that has to be true because under Maryland Court of Appeals law, it is the acceptance of a modification of an agreement is when that time period to opt out runs dry. If they were bound starting on February 2013, there would be no point of putting the language unless you opt out into that arbitration agreement. So because the arbitration agreement was formed after Dodd-Frank went into effect, it necessarily incorporates the arbitration restrictions outlined in Dodd-Frank. Second, it has repeatedly been superseded by additional agreements. To argue that this applies to the 2014 account that was open makes no sense because Mr. Lyons was told to sign a whole different agreement in 2014 when he opened that account. And then that arbitration provision was actually amended in 2015. There can't be 8 different arbitration agreements, 8 different account agreements that all apply at once. And under Maryland law, when there's any modification to a contract, even pursuant to a notice provision that's in a prior contract, that is a new meeting of the minds, a new formation of a contract. And that means, again, the law that applies at the time attaches as integrated into that contract. Finally, on the question regarding the scope of Dodd-Frank, PNC is simply trying to write out the language related to from the statute. PNC continues to focus on whether or not it's part of the transaction, but that's why there's a separate provision, the E3 provision, applying to any document related to. Here, the account agreement purports to provide a means of collecting money owed on a home loan. And that's the entire claim that Mr. Lyons alleges below, a TILA claim alleging unlawful collection on a home loan. It's precisely the kind of situation that E3 is designed to apply to. In conclusion, this court should affirm the district court's partial denial of the motion to compel. Specifically, this court should hold that the E3 provision restricts arbitration clauses in agreements relating to home loans and that the deposit account agreement relates to Mr. Lyons' home loan because it purports to provide a means of collecting payments on it. This court should also reverse the district court's partial grant of the motion to compel on the grounds that the 2013 account agreement actually postdates Dodd-Frank by 10 days and has been repeatedly superseded by other post-Dodd-Frank account agreements. This court should not allow PNC to write an exception into a remedial statute like TILA that is not based on the text or the structure of the statute. Indeed, if PNC can sidestep Dodd-Frank's arbitration restrictions here, its conduct will be a blueprint for every other bank looking to evade those restrictions or other regulations governing home loans. For those reasons, this court should affirm on the appeal and reverse on the cross appeal. Thank you.
Thank you, counsel. You all, appreciate you all being here. Again, we would love to come down and shake your hand. We can't, but know virtually that the spirit is the same. We appreciate you being here, and we wish you well and stay safe. Thank you so much, counsel.
Thank you, Your Honor.
Thank you.
Does the panel like to take a break, or should we proceed to our final case? All right.
I'm
I'm good to go, or
All right.
whatever y'all want to do. I'm fine.
Ms. Makesa?
Yes.
You may proceed.
Good morning, Nate. My name is Ashley McKaysa. Today.
Ms. Makesa?
Yes.
Your voice, we can hardly hear you, so if you could get closer, that would be helpful.
Is that a little better?
That's a lot better.
Okay, perfect. Good morning. May it please the court. My name is Ashley McKaysa, counsel for the appellants. The sole issue to be determined today is whether an impartial trustee should be appointed to overhear a trustee deadlock pursuant to Section 302C5B of the Labor Management Relations Act. The court should reverse the district court's order and require that an arbitrator be appointed to break this deadlock through primary reasons. First, Section 302C5B of the LMRA creates a compulsory statutory mechanism whereby an impartial trustee must be appointed to resolve a trustee deadlock. Second, disputes submitted for arbitration under the section of the LMRA are presumptively arbitrable. And lastly, the trustees in this case ultimately have the power and authority to make this modification, and the modification that they seek is merely an expansion of the definition of employer under the parties' trust agreement.
Well, ma'am, let me ask you this. Is amending a trust agreement, is it trust administration or trust policymaking?
I would say that it involves trust administration, because what the parties are seeking to do is allow other employers to be able to contribute to the fund and ultimately administer the fund under
Well, my follow-up question is, what contractual provision gives you the ability or power to amend the trust agreements?
If you look at Section 12.01 of the trust agreements, it explicitly says that trustees of the fund have the authority to modify the trust agreements.
Well, I'm talking about the arbitrator. What contractual provision gives an arbitrator the ability or power to amend the agreement?
Your Honor, within the trust agreements, there is not necessarily a provision that permits the arbitrator to do so. Yep. With respect to Section 302C5B of the LMRA, what it does is it creates a compulsory statutory mechanism to be able to break trustee deadlocks like in the present situation. And I think that becomes evident when you review Congress's intent in having enacted the statute. Section 302C5 of the LMRA requires that boards of trustees are equally represented by union and management trustees. I think in designing this provision, Congress was aware that this could potentially lead to deadlocks amongst boards of trustees, and there needed to be a mechanism for trustees to be able to break these deadlocks. And I believe in National Labor Relations Board, the Amex Coal Company, the Supreme Court recognized this, and it highlighted and outlined that there are differences with respect to how disputes are resolved between an employer and union in the collective bargaining context versus disputes that are resolved pursuant to Section 302C5B of the Labor Managed Relations Act. And in that case, the Supreme Court highlighted that under the NLRA, Congress explicitly rejected compulsory arbitration as a means of resolving collective bargaining disputes. Comparatively, when you look at the text of Section 302C5B, Congress here explicitly provides for compulsory resolution of deadlocks by neutral umpires. To my second point, disputes submitted for arbitration under Section 302C5B are presumptively arbitrable, and in this case, it is the appellant's position that the management trustees failed to rebut the presumption of arbitrability inherent in these types of disputes.
That presumption doesn't exist when it's a provisional. We're talking about a provisional change.
Your Honor, I see your point. However, I think, in the district court's opinion with respect to the basic provisions clause and expanding the scope of definition of employers, when you look at the definition of employers at present, that definition already contemplates permitting non-STA employers to be able to contribute into the fund. So I do believe that the union trustees' proposed modification is truly a clarification on that definition under Section 1.01.
Well, they did.
Well, ma'am, let me ask you this.
Go ahead, Judge Floyd. Go ahead, please.
I was thinking the basic provisions clause unambiguously forecloses an arbitrator from changing or modifying any basic condition within the agreement. Is what the activity is the subject of this appeal. Isn't that a basic provision?
In a sense, yes, and I, Your Honor, I will agree to that. However, I think the district court in this case failed to take into account, again, it's a compulsory statutory mechanism, and it's a very unique situation when trustees deadlock on an issue, and an arbitrator in this case stands in the shoes of an impartial trustee. So therefore, so long as the trustees in this case have the authority to make this change or modification, which I argue that they do under Section 12.01, the arbitrator has the same powers and authorities as well.
So, counsel, it sounds like, I just want to make sure I understand. It sounds like you're conceding that the, change in the definition of employer would be a basic provision of the agreement, which would hurt you contractually. But you're saying that the statute is your vehicle for arbitration, that overrides the agreement?
Correct, because the arbitrator in this case would be considered an impartial trustee. And even in, Senator Ball's statement, who was in charge, one of the two sponsors of this agreement, they use the language impartial trustee. And in this case, the impartial trustee or arbitrator, if he were assigned to break this tie vote, that's essentially what he would be doing. He would be breaking a tie. He's not writing any language. We're not asking him to give us a definition of employer.
But the and on that issue, I think Judge Floyd may have asked this earlier. Do you agree that for that issue, for you to prevail on that issue, that the definition of employer, we must decide that falls under the administration of the trust fund? Or do you not think that's a standard that applies?
When you read Your Honor, when you read all of the cases on this issue with respect to Section 302C5B, I'm sure, as you know, there are very limited cases on this issue. But when you distill them, ultimately, Section 302C5 will apply, and this issue could be an administration of the trust, so long as the trustees of the case ultimately have the authority and the power to make this modification. And so long as the trustees do have that authority, I believe that Section 302C5B is triggered.
Counsel,
So, well, let me ask you. Go ahead, Judge Gray.
you're arguing in a circle because to have your reading, you would just eviscerate 302's restriction completely. Basically, if the trustees can do it, then everything is arbitrable if they're deadlocked. That's what you just said.
Your Honor, I would humbly disagree in the sense that not everything is arbitrable. So long as the
one of which is basic provisions of the contract changes, correct?
In a sense, yes.
Is that correct? Is that correct, counsel? One of those restrictions is that those are the basic provisions if that's the subject, then that's not arbitrable under 302, correct?
Like I stated earlier, I think it's essential here.
I would like you to answer my question, counsel. I know it may be hard. I don't think it may be difficult. It might be hard to give the answer, but it really is it's a basic provision of the agreement, isn't it?
The term employer, Your Honor, yes.
Yes, it is. And your vehicle for that is under 302, and that is a clear restriction by the very letter of the statute.
Your Honor, I do not believe that Section 302C5B provides a clear prohibition on an arbitrator or impartial trustee being assigned to resolve this deadlock.
Well, ma'am, did you make that stand in the shoes argument about an impartial arbitrator? Yes. In the district? You made the argument?
No, we did not, Your Honor.
Well, wouldn't that issue be waived?
I believe what we requested in the district court, Your Honor, is that the arbitrator would essentially have a stamp of, you're required to stamp approval of or break the deadlock in this case.
You argued that in the district court?
I will have to confirm, and I can double check the joint appendix on Untitled. Now, going back to my argument, the trustees ultimately do have the authority to amend the trust agreements, and they have previously modified and expanded similar definitions. In 1977, the parties have modified the definitional provisions with respect to the definitions of employees in this case back in 1977, demonstrating that, again, the trustees have the authority to make this type of modification. And again, this is evident under Section 12.01 of the trust agreements, wherein that provision states the provisions of this agreement and declaration of trust may be amended by the Board of Trustees. Here, the union trustees are proposing something similar with respect to the definition of employers that are ultimately being able to contribute to the fund. Now, lastly, if this modification were to be blessed by an arbitrator, the union's proposed change would not require alteration of other provisions of this agreement. And it's simply a request by the union trustees to permit non-STA employers to be able to contribute to these funds. As such, the union trustees in this case are requesting that the district court's order be reversed and that an impartial trustee be appointed to break the deadlock amongst the union and management trustees. Your Honors, I'd like to reserve the rest of my time for rebuttal, unless you have further questions.
Thank you, counsel. Mr. Collins? You're muted. You're muted.
Thank you. My apologies. Michael Collins on behalf of the management trustees of the 4 funds at issue in this case, the STA ILA Pension Fund, Benefits Fund, Severance and Annuity Fund, and Holiday and Vacation Fund. These funds are creations of the collective bargaining parties. In this particular case, the collective bargaining parties are represented on one side. The union is represented by the ILA locals 333, 953, and 1429. On the management side, the STA is an association of all the employer members as well as the ocean-going carriers and service companies at the Port of Baltimore. There are collective bargaining agreements that apply and work to fund these particular fringe benefit funds. They start with a master contract between the ILA and the USMX, which is the United States Maritime Alliance. The STA is a member of the USMX. USMX and the ILA negotiate a East Coast to Galveston, Texas agreement called the Master Contract that provides for a fringe benefit contribution that's used by the collective bargaining parties and individual ports to fund these particular fringe benefit programs. And Baltimore is very fortunate to have some very highly funded programs, including, a pension plan that far exceeds all the pension plans amongst all the ILA represented ports in the United States. The motion that was made was that anyone who signs an agreement with the ILA or its locals should be deemed an employer under the agreement. And that is clearly, as counsel has conceded on behalf of the union, a change in the basic provision of all 4 of these agreements, and creates literal havoc when you talk about how you would administer such a change in a multi-employer environment such as the one that we have. In terms of just looking at the LMRA and how that might apply in this case, this is not an issue involving the administration of the funds. They want to transform the relationships of the parties. Conceivably, with this motion, should it go forward, a member employer of a failing pension plan in Savannah could simply glob onto our pension fund in Baltimore, and suddenly you have an employer with a contract with the ILA paying contributions into our funds and gaining the benefits of a fund that's firmly in the green zone, for example. That is not something that is ever contemplated by the parties, and that is why there is a specific restriction on what an arbitrator can and cannot do. And the provisions clause makes it very clear the arbitrator can never be in a position where he's amending or modifying a basic principle of the agreement. The union has conceded that this is a basic principle of the agreement, the definition of employers. So what we have here then is a provisions clause that bars the appointment of an arbitrator as some type of neutral stand in the shoes of a trustee. He can't stand in the shoes of a trustee because he's not permitted to under the express conditions of the contract. The district court was quite right. The idea that he's just standing in the shoes of a trustee it's a difference without a distinction in terms of his inability to modify or amend the contract, and that's clearly what they're trying to do here. If you look at the case law that governs this area, it's clear that although a contract may contain an arbitration clause, the court has still got to look at that arbitration clause. I'm sorry, I don't know what. I apologize. My computer somehow takes my phone even when I have it turned off. My apologies. But to get back to where I was, in terms of the LMRA, I mean, it's pretty clear that it doesn't apply where there's a specific and explicit, in this case, provision that denies the arbitrator an opportunity to amend a basic provision. That's what we have here. Seems to me the unions conceded all the points that were set forth by the lower court. The lower court found that the dispositive question was whether the definition of the term employer. The court found that there's explicit language in the trust agreements that the arbitrator does not have the power or authority to change or modify any basic provisions of the agreement. The bargaining parties placed restrictive language with respect to the arbitrator's authority to change or modify the agreement. The lower court determined that in a legal document, the word provision refers to a clause or clause in a statute, contract, or other legal document. Looking to Black's Law Dictionary under Merlin law, it's an objective view in terms of contracts. It's ordinary meaning of the word provision. This is, as the union has noted and conceded, a basic provision of the contract. And the court went on to find that in the context of a series of agreements established between a union and a management association, the court is compelled to conclude that the definition of which entities constitute employers under the agreement unambiguously constitutes a basic provision of the agreement. We agree. The court was similarly unpersuaded by the plaintiff's argument that the arbitrator wouldn't be changing any basic provisions to the agreement, but only deciding to implement the plaintiff's motion to make a change. But as the court pointed out below, that's a distinction without a difference, which would require an order from the arbitrator that would have the effect that of changing the basic provision, essentially. Just taking a step back from all of this, if you think about how people gain these fringe benefits to begin with, there's an entire galaxy of interlocking agreements and collective bargaining agreements that set forth such things as, how do you qualify for a pension? What's a good pension year? All of those things would be dramatically affected by this. The STA has its members collected in an association so that it can hold together such things as seniority amongst multi-employers. How many hours does someone work under what they call bargaining unit work, which is distinct, for example, if you're out on workers' comp or something like that. So all of the different things that you'd need to qualify to even participate in these fringe benefit plans would be dramatically affected by the fact that a change in the definition of employer would leave an employer presumably able to join the funds, but without any of the other collective bargaining principles at stake. And that's one of the things that when the funds were created, that's why these restrictions were placed upon the arbitrator. Similar restrictions about changing the basic principles of the funds were placed on the trustees themselves. So even though this isn't a basic principles case, this is a basic provisions case because we're at a motion dismiss stage. It's clear that the lower court acted correctly and that section and that the LMRA just simply doesn't apply where the circumstances are such that there's a restriction on the ability of the arbitrator to make a decision such as the one that the union's asking them to make. Unless there's any other questions, I think that is the entirety of the argument. I could cite to you case law that supports our position. I think these are very general cases that basically move forward on several long established principles, but one of the clear and long established principles is that arbitration is a matter of contract and a party can't be required to submit to arbitration any dispute that they have not agreed to submit. And that's what we have here. The parties did not agree to submit amendments or modifications of the trust fund agreements to an arbitrator. And I believe that at this point, that is the correct response and that the lower court's decision should be affirmed by this court.
Thank you, Mr. Collins.
Thank you.
Ms. McKesa, you have time reserved.
Thank you. Yes, I would like to first address, I believe it was Judge Floyd's question as to whether the issue of an arbitrator stands in the shoes of a plan trustee was addressed in the district court. And I wanted to highlight, I believe at Joint Appendix 131, what we did argue was we're just asking for a stamp of approval for an arbitrator to either say yes or no. You know, the trustees proposed expansion to the term employer is permissible in this context. The second thing that I wanted to address in response to Mr. Collins's argument is that the LMRA does not apply in this case. And I just would like to reiterate that it is the union trustees' position that it does in fact apply, because all of the circuit courts who have addressed this issue ultimately say that 302 applies so long as the trustees themselves have the authority to modify the authority to address the issue at hand. The last point I want to make is that what the union trustees are ultimately asking is for other employers who work at the Port of Baltimore to potentially be able to contribute to the funds. And if this proposed expansion were to occur, I do want to emphasize that nothing seismic will necessarily happen. For other employers to be able to contribute to the funds, the union would have to step outside of its role as a fund trustee into its role as a collective bargaining agent, enter into a collective bargaining agreement with other employers at the port. And again, this is employers at the port. We're not asking for every single employer in Baltimore or Maryland to be able to contribute. These are employers that essentially do the same thing as the STA member employers. The only difference is that these employers are not members of the STA. From there, the union would have to enter into a collective bargaining agreement with these non-STA employers. They would have to agree to some rate that those employers would be able to contribute to the funds. And then the union trustees would step back into their role as fund trustees, and the funds would operate, and the trustees of the funds would have a fiduciary duty to be able to administer those funds. So there are steps that need to happen, and there's no huge change that the union trustees are ultimately asking for in this case. There are steps and stops that need to happen before anyone and everyone would be able to contribute to these funds, as Mr. Collins pointed to. Unless you have any further questions, I just would like to reiterate that the appellants in this case request that the district court's order be reversed and that an impartial arbitrator be appointed to overhear this deadlock. Thank you.
Thank you so much, counsel. Appreciate it, Ms. McCasa and Mr. Collins, for your fine help and your able representation. We can't come down and shake your hand, but nonetheless, we greet you and appreciate your being here, and I wish that you be well and stay safe. And thank you so much. And with that, I will ask the deputy clerk to recess the court until this afternoon.
And wishes to you, Judge Gregory, and the panel. Thank you very much.
You're welcome.
Thank you.
Thank you. Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.